Yes, ma'am.
Ma'am, start பண்ணலாமா?
Yes, sir. Yes.
Good morning to all dear participants. I extend warm welcome to all the faculty and research scholars to the Faculty Development Program, Intellectual Property Rights, organized by Department of Computer Science and Engineering, Meenakshi College of Engineering, West Kekanagar, Chennai. I would like to welcome our management member, principal, head of department, all other department head, and my dear colleagues. I take great delight to welcome to our resource person, Mr. A.B. Rajsekharan. He is the principal founder of the leading IPR law firm, Rajsekharan Associates. He is a patent and trademark attorney, having over 18 years of experience in intellectual property rights, administration, prosecution, and enforcement. He has published widely cited articles on IPR law in leading journals. He also teaches intellectual property rights at the Premier Technical University in Chennai. He is admitted to the practice in all courts in India and frequently appear before the district court in the Chennai and the Madras High Court and the Intellectual Property Appellate Board. He believes that continuous learning can make us into perfection towards personal and professional life. Sir, I welcome you, sir.
Shall I begin?
Yes, sir. You can start, sir.
Yes, sir. Yes, sir.
Thanks, Uday. Thanks for this introduction.
Thank you, sir. Thank you.
Thanks for that. Good morning to all. I'm happy to see so many of you have signed up today to learn something new. These are trying times that we're in, but still, we have some hope. And the way you people have, what would I say, happily signed up for something new, it shows, this hope can be sustained. I thank the management and staff of Meenakshi College of Engineering for giving me this opportunity to be with you today, to introduce you to intellectual property rights. And we're going to, because since most of your faculty members in engineering colleges are research students there, so our emphasis is going to be on patents. And I'm just going to give you an overview of various intellectual property rights, but still the emphasis is going to be on patents. I'm audible? Can you hear me loud?
Yes, sir. Yes, sir.
Okay.
You are
Please
audible, sir.
stop me whenever you think that I'm not clear.
Yes, sir. Sure, sir.
Okay. So these are the topics that we're going to cover today. I'm just going to give you an overview of intellectual property rights, particularly copyright, trademark, geographical indication, industrial designs. And then later on, we're going to see patents in detail. This is going to be a one-hour session. So maybe I'll spend about 45 minutes to 40 to 45 minutes on this. Then I'll also take questions. We're going to spend more time on questions. I'm not sure whether I can ask you questions during the. I can take questions during the program itself. Maybe at the end of the thing, I will surely take some questions. See, in intellectual property, not just intellectual property, most of you would have heard about these rights, particularly patent, copyright, trademark, very frequently, and most of us use them interchangeably. For example, if someone has to say, they say you don't have a patent for this. I have trademarked this. Do you have a copyright for this? In general communication, we tend to use these words interchangeably, but the fact is they are not interchangeable. They are different rights per se. Patent is different, copyright is different, and trademark is different. They are granted for different subject matters. So we're going to see that. See, like physical property, even intellectual property is also a property that can be transferred. That can you can do what you want, the way you deal with physical property, like a piece of land or a building. But the difference lies. These are all intellectual creations. These are all what we call them as intellectual assets. These are creations of the mind. Particularly if we look at industries, most of the industries survive on these rights, like patent, designs, trademark, and other things. They survive on this. So these rights actually originate from industries. So originally they were called as industrial property rights. So when they clubbed the copyright together, then it became intellectual property right, because copyright is an artistic creation. When they it may be used in industry, it may not be used in industry, but still. When they combined the various industrial property rights, which are patent, designs, and trademark, along with copyright, then the terminology changed from industrial property rights to intellectual property rights. So, these are all creations of the mind, like inventions, literary and artistic works, or symbols, symbols, names, like a trademark or a brand, or the outer packaging itself that can be used in commerce or, any trade. These are the rights that are associated with it. Generally known, as I told you, patent, designs, trademark, copyright, generally known. These are new rights, jar of indications, the semiconductor integrated circuits. They know the outer design of the integrated circuits can also be protected by in an a specific right. And plant varieties, for farmers, what they do is they breed the different varieties of plants. Even they also can be protected. There's a separate department for that. There's a separate right also that accrues for that. So these are the things. But today we're just going to see the major intellectual properties like patent, designs, trademark, copyright, and geography indications. And most importantly, we should know ideas per se. Ideas itself is not protected by any right. Idea, you just cannot protect any idea that is on your mind. You'll have to express it in some form. Let's say you have a story on your mind. You have an idea for a very good story. You can write a short story. You can write a novel. The moment you put that into practice and into writing, immediately a right occurs on that. That is called copyright. Okay, let's say you write a novel, or you write a short story, or you take a film, short film, or you take a motion picture, a bigger film, or the ideas on your in your mind, you go and draw something. Immediately you get a right for that. That is copyright. Or you think a better way of doing something. Tomorrow you're not able to wash your vessels, and you want to find develop a new kind of a dishwasher. The idea is in your mind. The moment you sit down to in your workshop and start doing it, then you create a new kind of a dishwasher. Now you can get a patent for that. Or you're not satisfied with the design aspect of a television, the outer design of a mobile phone. You change the design, then you get a design right for that. So the idea per se is not protected by any of the intellectual property rights. Only the expression of idea, you'll have to express it in some form, either in writing or as a product or a process or something else, for you to get a right for that. And thirdly, these rights are generally called negative rights. In the sense, that means there is something called the positive rights. Positive rights allows you to do something. The moment you get the right, it allows you to do something. Let's say you get a permission to build a flat. It allows you to build a flat. Whereas these rights are called negative rights. Because you got a patent, for your invention does not mean you automatically allowed to go and manufacture it. You will have to get permission from various authorities to get to start manufacturing. It does not grant you an automatic right. But what in turn it gives you is it prevents others from doing it without your permission. That is what we call as negative right. It prevents others, third parties, from copying your invention, from working your invention, importing it, doing whatever it they think without your permission. So we call them these rights as negative rights in law. Then again, like as I told you, like any physical property, these are all transferable rights. You can transfer to anyone. You can mortgage. You can assign. You can license. Like any other thing, you can do whatever you want with these rights. There are certain banks that can actually where you can pledge your trademark brands and get loans out of that. So this is the basic introduction. Then we'll see each of these rights separately. The first we want to see is copyright. Copyright, as I told you, it's generally granted to original literary work. It should be original literary work, like a short story, novel, or a musical work. Any song or any other composition, you get a right for that. Artistic or audiovisual work. Artistic means it can be a photographer, it can be an artwork, or it can be an audiovisual work like a movie. When you look at a movie, there are a bundle of rights there. The story has a copyright, the screenplay has a copyright, the direction has a copyright, the music that goes into it that has a copyright, the songs it has a copyright, the dance sequence they have a separate copyright. So the bundle of rights actually. Okay, if you just look at this image, picture, can you see this actually? It's clear, right? The presentation is clear, no? Hello. Hello.
Yes, sir. It's clear.
Okay, the presentation is clear. Okay.
Yes, sir.
Okay. Okay, if you just look at this image, you will find Ilayaraja composing a song. Okay, the musical notation, the way is written down in a musical, notations, that is protected by copyright. Let's say then he composes it, the music is conducted. That recording is actually again protected by copyright. Not only that, someone has taken a photograph of this. Even that is protected by copyright. Who has taken a photograph of this, he gets a copyright for that. You would notice that. He says, music director Ilayaraja giving notes to his crew while composing music for a film. Within bracket, it says photo EPS. That means some gentleman called EPS has taken a photo of this. He gets a copyright for this photograph. So, when you look at something, you'll notice, it's not a single right, the multiple rights associated with it. Okay. Now, what are the rights associated with copyright? Means rights of reproduction. You can reproduce it. You write, you type it, you take, photocopies, or you print the books. You can take, a number of books that you can start working on that. Any book, you'll see even your textbook, you will find copyright for this author or copyright for this publisher or something like this, and it will give you detail year of copyright also. That is the copyright information that you'll find on any book that you see. Okay, rights of reproduction. You can communicate with the public. Then adaptation, you can adapt it to whatever way you want. For example, the story, you got a new story, you can adapt it for a television serial, you can adapt it for a picture drama, you can adapt it for a motion picture, you can adapt it for a short film. You can do whatever you want. That story is yours. Naturally, whatever you make, since you associate with other people also, they also get subsequent copyrights on that. But the original copyright for the story still belongs to you. And translation of the work, but let's say you write a novel in Tamil, you can have it translated into any language like English or Hindi, whatever you want. So the copyright for the original work belongs with you. He has to, who is going to translate it from Tamil to English? They have to get permission from you to get translated to translate the work. The English translation, he will get a copyright. But for the original translation, original work, you still have the copyright for you. And all of these rights, for whatever right you take, they are actually limited by certain time periods. For example, for copyright, it is generally 50 or 60 or 70 years, as the case may be. Some countries grant 70 years, some countries grant 60 years, some countries even grant 50 years from the death of the author. Let's say, someone conducts a music at, when he's 35 years old, but he dies, in the age of 80. From 80, you'll have to add another 60 years to that. So after 140, rightly speaking, for the particular music, 45 plus 60, you get about 105 years copyright on that. Okay, is this understood? So let's move to the next thing. These are all very, very common. You will naturally would have seen this every day. We see trademarks. There's nothing that we use without trademark, from the toothpaste to toothbrush to oil to rice to salt. Whatever you look at, whatever we can think of, there's always a trademark associated with it. And this trademark, if you just if you ask me to define it, it actually distinguishes one product of one person to another person. That's the core thing. It actually helps distinguishes between competing goods. For example, paste. Paste is a product. There are at least 10 to 15 brands on paste. You'll know. The moment you walk into a supermarket, you will know when you're looking at a red color, carton, the outer carton. You're looking at a Colgate paste, and a blue color thing. Maybe it would be a Sensodyne or anything for that matter. Green or yellow, it could be any brand. For example, it could be an Ayurvedic paste or something, whatever it is. So, but this Colgate or Close-Up or Pepsodent or Sensodyne or anything, this helps people to distinguish competing goods. For example, I would associate with certain quality with certain with brand. I know if I'm going to buy a Colgate paste, this is the quality. I know I'm going to get rid of it. Okay, if I buy a Close-Up or Pepsodent, since I've been using them continuously, I know what is quality or what can I expect of it. So the brand allows you to judge before buying anything. The consistently buy a particular brand. Because there's some goodwill associated with brand. When you look at Bata shoes or something, there is some they are good shoes. or when you look at Amul butter, they're very good butter. So, but this brand over a period of time, it accumulates certain goodwill by continuous, consistently maintaining its quality or whatever it is. And like copyright, trademark also has a time limit. It is for 10 years initially, but you can renew it in perpetuity. You can renew it every 10 years. So this can go on forever. For example, some brands like Britannia or Bata, they are in existence for more than 150 years now. Okay. So why whereas other rights have time limits. For example, patent will see it as 20 years. Design will see it as 10 years. Why trademark is in perpetuity means because for a period of time, this particular brand that accumulates certain goodwill in the market, enjoys certain goodwill in the market. Let's say the time limit is restricted to 10 years or 20 years. At the end of 20th year, anyone can start manufacturing it. Anyone can start using the trademark. If you allow to do that, what will happen is the brand equity will go down. The value of the brand will go down. It will no longer enjoy the goodwill. No longer enjoy the goodwill associated with the brand. So therefore, it requires this particular brand is associated with a certain company for perpetuity. If you look at companies like Hindustan Lever or Procter & Gamble, most of these companies have 2,000, 3,000 brands associated with them, and some brands are more than 100 years old. So what they do is periodically they keep updating the trademark and periodically they keep on renewing the trademark also. Okay. Next is geography indications. This is again a new right actually. A new right, at least in India it's about 10, 15 years now. But maybe in Europe it's old, but not very old actually. This says, certain goods have certain quality because of specific geographical origin. It possesses certain quality and reputation because it originates at a specific place. For example, if you make Tirunelveli and Alva in Chennai, you may not get the same taste, you may not get the same quality here. There are certain reasons why it is made in Tirunelveli and why it is made that way. It can be for anything. For example, it may not be possible for you to grow Nagpur oranges here. Okay. And in the same way, if you just look at something like weaving, Kanchipuram saris, they have a specific weave, and over a period of time they've accumulated knowledge. Most of the people in and around the Kanchipuram, they know this is the kind of yarn they're going to use, this is the weave type they're going to use, this is the color they're going to use, and over a period of time this knowledge gets accumulated. And by looking at the saree itself, you'll know whether it is from Mysore or whether it is from Kanchipuram or whether it is from Arni or something, because that particular area gets that reputation. Therefore, what happens is this right, it is called geographic indication. This right is given to the producers of that region. Only the people associated, living in that region and it is made in that region can, and making that product in that region can use this tag. What we call them as GA tag. No one else can use it. Use this tag. For example, you cannot manufacture Kanchipuram saree here in Chennai and use and call them as Kanchipuram saree. Only it has to be, there is, you have associations there. Kanchipuram Silk Weavers Association is there. They get this tag, and you'll have to be a member of the association to use Kanchipuram saree, silk sarees. And again, like trademark, it is again in perpetuity. You can keep on renewing it, and you get a what would I say? You continue to enjoy the goodwill associated with the geographic indication. This example which I'm giving you is a Tanjore doll. Okay, I can give you a lot of examples of geographic indications. Darjeeling tea, Assam tea, Nilgiris tea, or Scotch whiskey, or kind of cheese in the number of cheese varieties that you find in Europe, or even here Bhavani Jamakalam. So many varieties that you can talk of. This is geography indication. Next is design. Design is what appeals to AI. When you look at a product, what literally appeals to AI? The outer shape, it need not have any function. The outer shape, for example, we see a hand watch, a Lifebuoy hand watch. Okay, this is the design they got registered. So even if you remove the lifebuoy label out of it, if you just remove the lifebuoy label out of it, it is a lifebuoy hand wash container. So like that, there are so many things. For example, a Good Day biscuit or a Britannia, what is the milk bikis? They have a specific design. This design is existence for a long time. The moment you look at the biscuit, it's a milk bikis. The moment you look at Good Day biscuit, it is a Good Day biscuit, even without seeing the name on that. So what companies do, industrial companies or anything for that matter, the outer shape, the way designed the outer shape, what appeals to the eye. The moment you look at something, what immediately comes to your mind when you look at something, that is protected by design. For example, I'm not sure whether those bottles exist now. When 20 years ago, when you look at BVD coconut oil bottle, it is a BVD coconut oil bottle. It's green in color. It has a specific shape. You need not even see look at that name label on the bottle. You will know these are all. This is BVD coconut oil bottle. Like that, there are many products. Coca-Cola bottle. The outer shape itself, you can know it is Coca-Cola bottle for a distillery water again, or Kinley or Aquafina. You look at anything. All of them are protected by designs. And this design exists for 10 years. After 10 years, anyone can start making that. Next is patent. We'll see patent in depth later, but I'm just going to give you an introduction. Patent is a right granted for limited period to an inventor in respect of an invention. So, three things are important here. It is given for limited period. What we call as brief monopoly to an inventor who invents something in respect of an invention. It has to be an invention. We'll have to see what is an invention. Patents are granted for invention only. Okay. When you get a patent, what happens is, as I told you earlier, it is a negative right, like any other intellectual property. It is also a negative right. It excludes others from manufacturing, using, selling a patented product without due permission from the patentee. You will have to get permission from the patentee to begin using it. And again, the timeline and time period for term period for a patent is 20 years. 20 years from the date of filing. For 20 years, you have a right. After 20 years, anyone can start manufacturing it. Anyone can start working it. This is a new patent that we received about 4 months back for one of our applicants. It's a safety valve for a gas stove. Sometimes you accidentally, what happens is the flame gets extinguished, maybe by a blow of air or something. Flame gets extinguished, and you are in another room. Still, gas continues to come out, without flame. So that is hazardous. So this device, what happens is, it senses the temperature. When the temperature goes below a certain, temperature level, automatically it operates and closes the valve. So what are the rights that we saw? I'm just give you a snapshot. This is a Nescafe coffee. What we call as instant coffees. Okay, a soluble coffee beverage powder. They got a patent for that instant coffee. What is inside this bottle, that is a soluble beverage coffee powder, and they got a patent for that composition. And trademark, Nescafe has got a trademark for the brand Nescafe, and even the Cap Columbia, another trademark you will find, even that is again protected by trademark. Design, the outer shape of the bottle, Nescafe bottle, is again protected by design. And copyright, the label, you'll find the label, color label, that is again protected by copyright. If they want, the outer shape also can be protected by copyright. So now we come to patents. Okay, as I told you, it's a brief monopoly right over an invention. It is generally granted by a nation state, by a country, or it can be even an intergovernmental organization like European Patent Office. More than 20-25 countries or their members in the European Patent Office. UPO grants patents. Likewise, even Africa, there's another organization called ARIPO. So it can be an intergovernmental organization or a country like India, Pakistan, US, Japan. Okay, it is territorial right. That means this right is valid only in the territory in which patent is granted. There is no such thing called world patent. For example, you after getting a patent in India, You cannot enforce it in any other country. You'll have to simultaneously get patents in whichever country you're interested in selling this product or marketing this product. There's no such thing called a world patent. Every country you'll have to apply and get a patent there. And what we particularly patents, we use the term quid pro quo in the sense in lieu of something. Okay, why does the state, the government gives you a monopoly, brief monopoly, which is for 20 years? 20 years it gives you a right and dissuades others from copying your invention. But you get to practice this invention for 20 years. In lieu of that, what is required from you is you'll have to disclose the invention. You'll have to completely disclose what is the invention about. You'll have to give diagrams. You'll have to explain the invention. You'll have to use, give the ingredients. You'll have to, explain how it is worked. So when you get, disclose everything, what happens is it adds to the common general knowledge. For example, there's a state of art. There's something, what is already known. Now, because you have disclosed everything, it is published. People get to see the new publication, and but they know there is something. There is a progress of technology. Progress of something. What was a ballpoint pen? Which was leaking. Now there's a new kind of a ballpoint pen, where the ink does not leak. So that's a better product that is out in the market. People read that. I know if there is some fault on that, they again work on that and come up with a better solution. So this disclosure is essential. If you're not disclosing it, keeping it as a secret, the technology, is stunted to that extent. For example, Coca-Cola, composition is not known. No one knows what is the composition of the Coca-Cola because they have not disclosed it. It's not published. It's not there anywhere. It is a secret. But someone, steals some that, disclose it to everyone. And the Coca-Cola composition is no longer a secret now. So to, prevent that, you will have to get a patent so that no one else copies it without, copies it or uses it without your permission. As I told you, patent is granted to an invention. Naturally, I'm trying to differentiate invention from discoveries and innovation. Discovery is what is there in the nature, what already exists, and you just put in time and effort to find what is already there. Maybe some element in the periodic table or new kind of a species in in Amazon forest. These are all discoveries. They are already there. All you have to do is just go and try to find that. Whereas invention is you're completely giving something new to the world. Okay. And every country has a definition for invention, what they think is invention. In India, an invention will have to be a product or a process. The subject matter will have to be a product or a process, which is novel, involves an inventive step, and has an industrial application. So these are the three requirements, 4 requirements I would say. It has to be a product or a process. It should be novel. It should be involve inventive step, and it should have an industrial application. Product or a process, naturally you know. A product, like a pencil, okay, or a process of making a pencil. A product, let's say a tablet, a paracetamol tablet or something. A process of making that medicine. Both of them can be patented. And it should be novel. Novel in the sense it should be new. No one else before the date of filing should have been aware of this invention. It should not have been anticipated before the date of your filing. It should not be there anywhere in the public domain. It should involve inventive step. That means it should be more than novelty. It should be for example, merely what would I call as progress of technology. For example, okay, you take a metal bucket. Okay, metal bucket is already known on that. Metal bucket people have been using. Suddenly, you have a new material called plastic, and you use plastic to make a bucket. Would you get a patent for the plastic bucket? No, you would not, because the law says it is merely progressive technology. We used a new material that is available now, made available now. That's it. You have not done anything. So it should be more than a workshop improvement. You should have invented something that is more than a workshop improvement. For example, you have a fan, and below the fan you attach a light to it. So once you switch off the fan, you also get light. There's nothing there. What you've done is just taken a ceiling fan and taken a bulb and attached it to a ceiling fan. You've not done anything to it. Okay. So these things patent office actually judge. Okay, whether there is an inventive step associated with it. And third is industrial application. It should be applied in industry. It should be industrially applicable. It should be manufactured in industry. Naturally that means corollary is manually manufactured things are not patentable, because every product that is manually manufactured, surely there will be some difference. So only when you have an industrial manufactured, every tire that you make out of it, it will look the same. Every mobile phone you make out of it look the same. There will be completely uniformity. Okay. And it should not be obvious to a person skilled in that. In the sense, people who are skilled in the particular art, particular field of invention. For example, a chemical, you're looking at a new kind of a chemical composition. Okay, urea, fertilizer. Okay, a person who is completely has knowledgeable about fertilizer, when you show him this invention, he would not say, no, this is already known. I would have done this. All you have to do is take A and take B and mix them, and you get C. There's nothing there. It should not be obvious for him. It should be something more than that. Okay. And what are the things particularly faculty members like you or research students like you shouldn't be doing is, you shouldn't publish it without applying for a patent. The moment you publish it, you lose novelty. Okay. Then no longer you can, even though you publish it, it doesn't make any difference at all. By saying that I only had it published, that's not an excuse at all. It should not be in public domain, either by yourself or by any other means. So don't publish it. Don't invite press to disclose your invention. Don't put it on the YouTube. Don't put it on website. Don't share it by WhatsApp. Immediately apply for a patent. Then you start doing all these things. Don't disclose the invention to anyone before filing an application. Don't exhibit. Make a presentation. There are certain exceptions to it. For example, let's say the exhibition or a presentation you're making, in a seminar or in a learned society, or in some kind of a forum organized by the government of India, or an exhibition organized by the government of India. From the date, within 12 months, you can still apply for patent. But why do you want to take that risk? It will be difficult for us to prove it's a learned society. It will also be difficult for us to prove this exhibition is authorized by the government of India and that particular fact has been published in the Guest of India. Okay, so instead of that, before going into making a presentation anywhere, before exhibiting your product in scientific exhibition, immediately quickly apply for a patent, then go and do whatever you want with that. Okay, there are certain inventions not patentable. For example, discoveries, as I told you, discoveries are not patentable. Scientific theories, scientific theories per se are not patentable. Whereas an application of the scientific theory, using the scientific theory, you made something, then they're patentable. Okay, and mathematical methods, mathematical methods, they are again not patentable because there is no tangible product you get out of mathematical methods. Aesthetic creations, and they are again protected by copyright. They are not protected by patents here. Any scheme, rule, or method of performing a mental act, playing a game, method of playing a game is not patentable. Whereas a gaming device is patentable. But device to play a game is patentable, but a method of playing a game is not patentable. Method of doing a business, what we call as business method patents in the US, it's not possible here in India. A method of doing business is not patentable. And the program for a computer, okay, and computer programs per se, what we call is coding or a program. A program per se is not patentable. Whereas when you apply that to some kind of new device, some kind of a device that you develop as an embedded software, then the whole device is protected by patent along with the program that runs on that device. Otherwise, program per se is not protected by patent. Presentation information, like tabular column or anything for that matter, presentation information is not patentable. Anything that is offensive against public morality, like a machine that can kill 100 people at a single stroke, or a new kind of a cigarette, a new kind of a drug, but they are not patentable. Animal plant varieties, except microorganisms, animals and plant varieties are not protected by patent. So this is not exhaustive actually. There is in a few others as well, but I thought these are sufficient for you. Traditional knowledge are not patentable. For example, turmeric or neem, anything made out of neem, anything made out of turmeric, any new cure that you have developed, using one of the known things, they are not again protected by patent. In India, this is the timeline. After you apply for a patent, it gets published in 18 months. You can accelerate publication in the sense you can have it published within 1 month by paying extra fee. But generally, it takes 18 months for it to be published. Then it is examined by the patent office. An examiner of patent sends his report to the controller of patent. Controller sends us the examination report. You will get something called an examination report. It will contain all the objections on that application. Maybe you will say it's not novel, it is not inventive, it is obvious to a person skilled in that. The specification is not written properly, the claims are not written properly. There will be so many objections, maybe 10 to 15 objections will be there. Then you'll have to meet those objections within 6 months. We have the time given to you 6 months. Within the 6 months, you can make whatever changes the controller is asking you to make change. Then you can argue how your invention is different from the document cited by the examiner, cited by the controller. He will cite sometimes they will cite 4 or 5 documents saying this is already known by this patent, this is already known by this publication, this is already been anticipated by this document. Where he will cite 4 or 5 documents. Then you can go and argue how yours is different from what is already known in the art. So you file something called a response to the examination report. After reading this, getting the response to the examination report, he will grant you a hearing. You can go and appear before a hearing. You can argue, again, put your case before him. If he is convinced, then patent is issued, patent is granted. The whole thing takes about 24 to 36 months for you to get a patent. Now, but there are provisions where you can get express examination. If one of the applicants is women, it is examined and patent is granted within a year. Or if it is a startup, if it is a startup company, again your patent is granted within 12 months. Application of patent is generally applied on a Form 1. You'll have to make a formal request. These are all available online. You can take a printout of that and fill the bibliographic information, whatever that is asked from you, and apply. Okay, either an inventor can apply himself or he can assign the invention to anyone. For example, let's say you're all faculty members there in a college. You are the inventor, you invented something. Either you yourself can apply, provided your college allows you to do that, or you can assign your invention to the college. And the college can be the applicant, but still you will be the inventor, because companies or institutes cannot be the inventor. They cannot invent. The inventor will still be you, but since you have assigned the invention to the college will be the applicant. Meenakshi Engineering College will be the applicant, and Sudha will be the inventor. Okay, it is usually accompanied by a specification. We'll see what are the specific type. 2 different kinds of specifications we're looking at. Then a declaration as to inventorship, Form 5, what we call as Form 5. You declare these are the people who contributed for this invention. They are the inventors for this. Then if you have assigned it to someone, the assignment details, whatever it is. So these are the main things that are required. 3 major items. Okay, now we'll see what is the specification that should accompany an application for a patent. An application for a patent must be accompanied by a specification. Specification describing the invention. It should be a specification that completely describes the invention. Generally, there are 2 specifications or more. Are allowed. One is a provisional specification. Another is a complete specification. There is nothing called a provisional application or a complete application. There is only one application. The application is accompanied by a specification. It could be a provisional specification or a complete specification. For example, let's say your invention is not yet complete. Still you going to make some changes into it. Still you're working on it. Still you need time to do something on that. But the idea is with you. You want to protect it. What you do is you describe that idea. You describe what are the things that is possible that your invention can do, and what are the things your invention can be worked. So whatever it is, maybe 2-3 pages, you write something, and you can apply that itself along with the application. You can you can apply for a patent. Along with the provisional specification. The provisional specification need to be just 2-3 pages. It need not even have a drawing. Okay. So that way you get an application number, you get a filing date. Now that will be the application number and filing date throughout the life of the patent. Okay. So when you are in a hurry, when you think there's no other way you can protect the invention, you just need to file a provisional specification, application along with the provisional specification. Then go ahead, make your presentation. Go ahead and file send article for a journal or something. So submit a paper or do whatever you want. But file an application along with the provisional specification with describing your invention in 2-3 pages. Okay. From the date of filing the application with the provisional specification, within 12 months you'll have to file complete specification. But that is actually mandatory. If you're not filing the complete specification within the 12 months, then the application is deemed to have been abandoned. That means you're no longer interested in pursuing that application. That is understanding. Patent office will get and will abandon the application. Okay. So most of the times when I look at individual inventors, what I tell them is still your invention can be modified. You can still continue to develop your invention. So what you do is apply an application with provisional specification. You get a filing date and number. This will not change throughout the life of the patent or patent application. After you file the provisional specification, application with provisional specification, then you file complete specification. Or you can directly file an application with a complete specification. Let's say you got, your invention is complete. You have a prototype. Everything is ready. All you have to do is just go begin manufacturing it. Then you have all the information with you. Since you have all the information with you, you don't have to waste your time on application with provisional specification. You can file complete specification directly. You should fully and particularly describe the invention. This is the requirement. You should fully, particularly describe the invention. You should not leave anything out. Then you should end with the claims. You should end the specification with the claims. Claim what is your invention. What do you think is your invention? I'm just going to show you a sample specification. Many of you would have seen that, but still I'm just going to show you a sample specification, how a complete specification looks like. Okay, this is form to complete specification. You have the title and the applicant name here. And you have something called the field of the invention, what field this invention relates to. And background art. In the background art, you try to explain what is already known in the field. What is already known in the field and how is yours is different from what is known. You don't have to say how yours is different, but you at least need to say, what is already known before the data filing. What is already known that you don't have to know everything. What you know is a background art. What you know, that is sufficient. You don't have to know everything in the world. After you've given the background art, then you give the summary of the invention. Summary of the invention is a summary of what you think your invention is. Okay, 1 or 2 pages you write about the summary. Then you have the brief description of the drawings. What you're providing some drawings, right? Then you have to give a small description. What does the drawing actually mean to someone who reads the specification? Schematic illustration of working of the invention. Like this. Then you go ahead and give the detailed description of invention. The complete detail of the invention, what are the parts in it, how it is combined, how it works, and what is the process involved, and what is the output that you can expect out of it, and any variations that you're going to bring into known products, known things. All these things you'll have to explain here by referring to the drawings. For example, you will see referring to figure 1, figure 2 by referring to drawings. Every part will have a number. Burner, it's the metal strip. Okay, then you have delatching rod, gear. These are the parts in the in your invention. By referring to them, you explain your invention. After explaining your invention in full, then you go to something called claim. What you claim as invention. Many people assume claim should be something like, I claim this is my invention. I invented this. This is the best invention. These are all generally understood first claims, but for purpose of patent law, they are not claims. What you claim is what we call as boundary of the invention. What you think is the boundary of the invention. That means in a single sentence, you'll have to explain. You'll have to give what you claim as a boundary of the invention. What you think your invention is. What you claim as your invention is in a single line. For example, you will find full stop only here. What I claim now is I'm claiming a device for automatically switching off a stove having a fuel control knob to control flow of fuel to the burner of the stove. Now, what does the device has? I've given you the device. Said device comprises of biometric temperature sensor. These are the parts. Now, how each of the parts are associated. You're not looking at a geometry box. When you look at a geometry box, you'll have a scale, you have a divider, you'll have a compass, you'll have so many things. But these are all, disparate items. The items are strewn there. But whereas when it comes to patent, these items will have to be joined with one another in such a way that you have a workable product. For example, I'll tell you, a bimetallic temperature sensor positioned, close to the burner. That means, there is a temperature sensor and it is positioned close to the burner. Okay, burner is already disclosed here. A connecting rod connecting the temperature sensor to a latching rod. I have a connecting rod which connects temperature sensor to a latching rod. That means, here I give the combination. Here I say the position of something and what, the sensor is connected to something through what. All these things I'll have to give here in the claim. So when someone reads it, in his mind, you will know what is the product that he is looking at. What is the product that he looks at. So this is how claim will have to be written. You can check specifications of the patent office website, or you can go to Google Patents. Type any invention that you think of, and open the document and find how the invention is described and the claims are written. Application fee today for individual is 1,600 rupees and 8,000 rupees for companies and institutes. And along with the application fee, you'll have to pay something called request for examination fee to see as the patent office to examine your application. It is 4,000 for individuals and 20,000 for companies and institutes. Okay. Now I told you there is no such thing called world patent, but there is something called an international application. For example, rightly speaking, let's say you apply for a patent in India and it just gets published. Nowhere in the world you can actually apply for a patent. Wherever you apply for a patent, immediately that patent office will cite your publication in India and say, US is already known before the data filing in US. For example, let's say US patent office looks at your application, it will say your application or your invention was already disclosed in India on this particular date. So that is actually case situation. So to work on that, what happened was, maybe 100, 150 years ago, we came up with something called a Paris Convention. So in this convention, there are a number of countries, member countries. India is a member of the Paris Convention. So after filing in India, you have 12 months time to apply in other countries. Even if it is published in India, it is immaterial. So after filing in India, from the filing date, you have 12 months to file in any of the member countries. You can file in UK, you can file in UPO, you can file in Japan, you can file in China, you can file in US, you can file wherever you want. After, within 12 months from the date of filing in India. This is one way of doing it. Another way of doing it is patent cooperation treaty. This is again an international treaty where, within 12 months from the date of filing in India, let's say you file it in India, you can file something called an international application for a patent. Within 12 months, you will file something called an international application for a patent. That is called a PCT application. So by filing the international application for a patent, you get priority date in close to 120 to 130 countries. Okay, you get priority date. That means only you alone can file in those countries within 30 months. From the date of Indian filing, within 30 months you can enter any of these countries. You can file. Sorry. Within 30 months, you can file in any of the member countries. So you can use either the Paris Convention or the PCT. PCT, I would prefer PCT if I'm going to file in more than 5 countries. If it is less than 5 countries, then the Paris Convention is the best route. You will save money. PCT is expensive, but you get priority date in 120 to 130 countries. You don't have to file in all those countries. You can select, out of 120 countries, you can select which of the country you're going to enter, where you're going to file. But as I told you, merely filing this application does not allow you, entitled to a patent worldwide. You will have to still go and file applications in each of these countries to get a patent. With this, I end my session. Okay. If there are any questions, I can take questions now.
Thank you, sir.
Thank you.
Sir, one question in a chat box.
Okay.
That is there any qualification needed for the patent publishing?
Qualification?
Yes, sir.
No qualification is required. Anyone can file a patent. Even young child, even a child can apply for patent. There's no age limit. There's no education qualification. You invent anything. It could be as simple as a safety pin. It need not be even be a complex invention like for mobile phone or anything for that matter. It could be even a safety pin. And it's as simple as that. You would have not seen this yellow stick pattern post-it. This yellow color post-it stick notes. Okay, they are subject matter of patents. They are actually patented. The 3M had actually patented it. Now it is out of patent. So many other companies are manufacturing it. It can be very, very simple. All we have to just show is it is novel, it is inventive, and it can be manufactured in an industry. Only these three requirements are required by patent law. No other requirement is there. Anyone can apply for a patent.
Okay, sir. One more question. Is
Yes.
there any difference between copyright and trademarks?
Copyright and trademark.
Yes, sir.
Okay, that's what I told you. There's a difference between copyright and trademark. Copyright, as told you, it's for artistic work, literary work, or a photograph, or a musical work, anything for that. You get a copyright for that. Trademark is generally associated with the trade name, logo, brand name, and all those things. But what happens is, for example, let's say outer box. For example, Clinic shampoo. We just take the example of Clinic shampoo. Clinic shampoo from the time I seen Clinic shampoo, it has always been blue color, blue color sachet or blue color bottle. Okay, what they can do is they can get a trademark for that. The outer packaging, the packaging style, they can get a trademark for that. They also can get a copyright for that. The design, they also get a copyright for that. But as I told you, the copyright is limited to 50, 60 years. So the best thing is to get it trademark. You can actually, rightly speaking, you can get a trademark even for new kind of smell also, fragrance also. You can get a trademark for jingles. For example, the Airtel, Nokia, when you see advertisement, there's a small jingle, right? End of it. They got a trademark even for that also. You'll have to just give the musical notations and you'll get a trademark for that.
Sir, this question is from me. I'm working in a college. I need a patent. It belongs to college or individual, sir? Okay,
wonderful question. See, naturally when you join the college, they'll give you in the appointment order, you'll find a clause called intellectual property clause. Even if you don't have that, many colleges insist on that. In the sense, whatever you invent during your course of employment, in the college, it will be automatically transferred to the college. So you can be the inventor, but the applicant will have to be the college. Some colleges, they say, I'm not going to spend money on that. You can apply on your name. Many private colleges which I see, they generally allow individuals to apply patents on their name. And some colleges, for example, various ranking, NIRF ranking, other things, what they do is they ask the faculty members or students to invent something, and they in turn apply in their name. So either there could be expressly provided in a contract. In absence of a contract, still college can insist you to transfer the intellectual property to them, to assign the patent to them.
Okay, thank you, sir.
No problem.
Sir, one more question.
Yes.
Dr. S.M. Roy Chaudhary has asked this one. If I publish the patent this year, how long will this patent will sustain?
See, publication is not patenting. Patent. Okay, but the application is published. Okay, we file an application, then it is published within a month, or if you allow, if you don't pay any fee, they publish it after 18 months. That publication does not constitute. Does not mean that you got a patent right. Okay. After that, it will go for examination. If there is any hearing, you will have to attend hearing. Then it is patent is issued. Patent certificate is granted to you. After getting a patent certificate, it is for 20 years. 20 years from the date of filing the application. So, for example, let's say I filed the application in 2018. I had filed the application in 2018, and patent is granted in 2020. So, the 20-year time period is granted from 2018. Every year you will have to pay renewal fee. From 2018 to 2038, you got a patent right.
Sir, another question.
Yes.
After the time limit completed, for trademark and design, how can we secure or access it, sir? Should we renew it or any procedure?
I'm sorry, I didn't get that.
After the time limit completed for trademark and design, how can we secure or access it? Should we renew it or any procedure for it?
No, that's what I'm saying. No, for example, the design is 10 years. Patent is, I mean, trademark patent is 20 years. Every year you'll have to renew patent. Okay. Trademark, every 10 year we'll have to keep on renewing it. Before the end of the 10th term of trademark, you'll have to renew it. Okay, let's say I get a trademark in 2010. Now it ends in 2020. So before end of 2020, I'll have to renew it for another 10 years. So before the end of the term of the patent, I mean, a particular year, you'll have to renew it. There are specific laws in each of this, for each of these rights, which you'll have to follow.
Sir, what is the maximum author for single patent?
It can be any, you don't call them authors. Copyright, you call them authors. When it comes to patent, you call them inventors. It can be any number of inventors. We have applied for, 10, 15 inventors also. It can be anyone in the, all the members of a lab. It can be any number. And there's no limit. Even the applicant also can be any number of applicants.
Then all the applicant will have the equal weightage, or the first applicant will have the equal weightage?
No, all the applicants will have equal. If someone wants to take a license, he'll have to get license, from all the 10 persons. There's no such thing called, when you publish a paper in a journal, and I learned, in a scientific journal, we call them as first author, right? First named author. There's no such thing called first named inventor here in patent. First named applicant or first named inventor here. The professor name can be the first or it can be the last, it can be the middle, anyway. All of them have equal rights to the patent.
Sir, copyright is one-time procedure, or we need to renew it again and again?
Copyright is a one-time procedure. And then not only that way, I didn't tell you something on copyright. Copyright is something called a proprietary right. You don't have to go and register it. Once it is created, the moment it is created, copyright automatically subsists on that. What we call as proprietary right. It immediately you get a copyright on that. You will any book you take, no office can contain all these books, right? So most of the publishers, what they do is they just give the copyright information in the book. In one page of the book, they say copyright is for this particular author, for Jayakanthan, for Sujata, all this thing, and it gives that details. That is more than sufficient. Even photograph also, the moment the photograph is clicked and it is printed, automatically copyright exists on that. You don't have to go and register. Patent you'll have to register. Designs you'll have to register. Geography you don't have to register. Trademark and copyright you don't have to register. Okay, continuous usage itself will give you right on trademark. Okay, but registration, it will give you just a prima facie evidence that this trademark is yours. Okay, so that advantage only copyright and registration of copyright and trademark gives you. By registering trademark or copyright, you don't have to go and show anyone proof. That registration certificate itself is prima facie evidence. Whereas if you don't register, then you'll have to take, you'll have to prove in a court of law why, how this is your copyright, how this is your trademark.
Sir, another question.
Yes.
Suppose I want to apply for patent in Japan. I have to apply directly to Japan, or I can approach Indian Patent Office?
No, you cannot have. Indian Patent Office do not do that. Does not do that actually. Let's say you have an invention. What you have to do is you'll have to apply for a patent in India. Okay, within 12 months you can apply in Japan. In Japan, you will have to take the help of a local patent agent there, patent attorney, because they require address of service in Japan. You'll have to take the help of a local patent attorney in Japan for you to file the application. Or let's say you don't want to file in India itself, you want to file directly in Japan. Then you will have to take the permission of the controller. You will have to file something called a Form 25. Take the permission of the controller, seek his permission. If then he will grant you permission. He will actually check this invention relates to defense of India or nuclear material or something, but these are all certain requirements for which he'll have to see. If he thinks, it cannot be used for defense of India, then he'll allow you to file. So, taking the permission, you can go and file in Japan directly.
Sir, one more question from
Yes.
Natarajan. Is it possible to do any correction after submitting my application?
Actually, the specification is incurable. You cannot add new matter, but you can correct, for some matters which you think been wrongly mentioned, clerical errors, or establishing an actual fact. For example, the part where it should have been numbered to number 4, but you mistakenly numbered it to number 5. You can correct them. But other than that, you cannot make any corrections to the specification. It's incurable. When during examination, the examiner might ask you to explain certain things. What has been disclosed, he is not, he is not able to understand it properly, or it's not very clear. He can ask you to describe the particular thing, what has been already disclosed. You cannot, add new matter to it. So that is expressly prohibited by Section 57 to 59 of the Patent Act.
Thank you, sir.
Yeah.
Participant, is there any other queries?
Sir, can you please explain power of attorney concept?
Okay. Power of attorney is, for a patent, let's say, I am a patent attorney, I'm a patent agent. You want me to prepare the application, file, and get a patent on your behalf, then you will have to grant me something called a power of attorney. Okay, it is on Form 26 for patent, and likewise in trademark, there's another separate form for that, and copyright, there's a separate form on that. You'll have to grant me right, this power for me to go and appear before the patent office or do anything on a behalf before the patent office or any other IP office. So that is a kind of a legal requirement. I cannot go and practice before any of this office without this power of attorney, without getting power of attorney from you. I cannot do any act before any of the IP offices. So power of attorney is that. It's a kind of a contract agreement between you and me. You grant me.
Sir, another question, sir.
Yes.
How long it will take to get patent in India?
I told you, generally takes about 24 to 36 months now. It can extend to 40 to 48 months also. But now we know they're accelerating it. And since I also told you certain people can ask for express examination. If one of the applicants is a women applicant, they can actually get a patent within 12 to 18 months. If the applicant is a startup, again, they can get a patent within 12 to 18 months. If you are filing PCT international application and choosing India as a search authority, then again you can file express examination. And that is actually additional fee. You'll have to pay additional fee for that to do that. But otherwise, ordinarily it takes about 36 months minimum. 3 years minimum to get a patent.
Yes, sir. One more question.
Yes.
How to get a patent for medicine since the formula for the product would be same? Example, this question is from Gautam.
No, sorry, I didn't get it.
How to get the patent for medicine since the formula for product would be same? Example.
No, for medicine it can be a.
Sir, example paracetamol.
Okay. See, medicine, it can be a composition or a compound. Let's say you find a new chemical entity. Okay, and the chemical entity can exist in nature. Can exist in real world for less than an hour. Then you have to convert that into a compound. You'll have to add certain salt to make that, to increase the shelf life and other things. So that particular chemical entity, along with the salt which you are adding to it, you can apply for a patent. It could be, for example, A plus B plus C. give the final product is D, which is the drug, which is the medicine. You'll have to mention there. That is more than sufficient. It can have a specific chemical structure for that. Because naturally, since it's a new chemical entity they're bringing out, it will naturally have its own new chemical structure. You can explain, give that diagram also in the claim or in the description, and you can also give examples. What temperature you're adding A to B, and what you're doing. How you're mixing it, and whether you're boiling it, where the parameters, physical chemical parameters are maintained. For example, the pressure, the temperature, or what kind of additives you're adding to it. All these things you can explain the description, and you can claim for that particular compound or a composition. Generally, generally drug companies, what they do is they claim, once they have a new chemical entity in their hand, they claim hundreds of salts. So every possibility they'll have a patent. Out of it, maybe one or two salt only, one or two product only, they'll bring it in the market, and that will be that only that will be effective. Okay, so much of research is happening, in the medicine field, creating a viable product.
Sir, another question.
Yes.
Sir,
Yeah, please go ahead.
I have filed a patent.
Okay.
Is the other person
I'm sorry, I'm not able to hear you properly, ma'am. Your voice is breaking.
same concept?
Sorry, your voice is breaking. Can you repeat this
I
again?
have filed a patent. Is
Okay.
it possible for other person to do the same concept?
No. Since you have already filed a patent and it's published, other person cannot do it. But you cannot stop him then. After getting a patent...
Sir, it has not been published. Sir, it is not published. I have just filed it. My concept is not yet published.
Okay, you filed it. Okay, you filed it today, and someone comes to know of it. Tomorrow you start practicing it, start selling it. You're asking me whether you can stop him, right? Correct, no?
Yes, sir. Yes, sir.
Since you have an early date, priority date, and you already applied, your right is secured. But you cannot stop him, from doing it. After you get a patent, let's say after 2-3 years you get a patent, you can go after him. You can file an infringement suit against him and claim damages from the date of publication of your patent. From the date of publication, you can actually claim damages from it. You cannot stop him after filing.
Thank you, sir.
Yes.
Another person is asked, Mr. Pepian Periyasamy, for what kind of product patent is applicable, and for what kind of product patent is not applicable?
I gave there are list actually, not patentable inventions. Except that you can apply patent for anything. All you have to just show is it's not it's inventive, it's novel, it's industrially applicable, and it's not mere arrangement and rearrangement of known devices. For example, you take a device A and device B and you just arrange them. There's no output out of it. There's nothing new out of it. Except that you can actually apply for a patent for anything. For Section 3, as I told you, they are all not patentable inventions. Except that you can apply patent for anything. In addition to it, you'll have to show it is inventive. In addition to it, you'll have to show they are not mere arrangement, rearrangement of known devices, or you just mix A and B. There's no what could I say? You don't have output that is efficacious.
Sir,
Yes.
Ms. Violet has asked one question. Can I search for inventor that have already been patented?
Inventors.
Where can I search it?
You can find what she is asking is whether I can find and search invention that already played, right, in that particular area where she can. Yeah, she can search Google patents. She can use Google patents. She can even go to the Indian Patent Office to do a search. But Google patent, you get global, publications, patents and publications around the world. In the Indian Patent Office, you will get information only application filed in India. Then Google Patents, you can use keywords. For example, let's say you need to find inventions on diesel engines. She just needs to use the word diesel engine. And let's say she wants to use some additives for fuel, fuel that can be used in a diesel engine. She can use fuel, diesel engine additives. So the number of keywords she can keep on, increasing. Still, she finds the invention that is relevant to her.
Sir, can I obtain patent for software related inventions?
As I told you, ma'am, software-related inventions,
Invention.
program per se is not patentable, but software-related inventions are patentable in the sense if you apply, if the program is running on something like an embedded system, you can get a patent for that particular device. For example, you cannot get a patent for a new kind of search engine. There's nothing, no output there, no tangible output there. It's just a program running on a computer. You have to, when it runs, the output is you enter a keyword and you get a search result. There's nothing there. Whereas, for example, two, three devices are working together using this program, and it gives you a different kind of an output. For example, let's say an automated lathe machine, CNC machine or something, or new kind of a projector, a new kind of a mobile device, anything for that matter. The device itself is running on, the program runs on the device. You can get a patent for that device along with a computer program. The program itself cannot be patented. You can get a patent as a system, what we call a system claims, as a product. See, we got got patents even for cloud systems, run on clouds, other things.
Sir, I think that's all for the question session, sir.
Okay.
Uday, sir?
Yes, ma'am.
You can go for vote of thanks.
Okay, ma'am. Thanks to all who have helped us in making this faculty development program such a resounding success. Heartfelt thanks to our chief guest, Mr. A.B. Rajsekharan, for gracing today's faculty development program. Thank you, sir, for your excellent presentation. Very interesting and informative session. Once again, I thank you, sir, on behalf of Meenakshi College of Engineering.
Thank you again for giving me this opportunity to, share my, thoughts on intellectual property rights. I'm so happy to be here. If there's anything, you can still write to me. My email ID is available with you people. The phone number is also there. If there's anything, I'm still there to be of any assistance to you.
Sure, sir.
Okay. Sir, I'm Tirupura Sundari, Head of the Department, Meenakshi College of Engineering. I would like to thank you over here for coming in this online session, because during this pandemic, what we thought is we'll use this time efficiently, and you had come over here and you had given us a very eye-opening session. I hope a lot of them will have a great idea in IPR, how to file the patent, or they may get and what is the trademark, what is copyright. So they would have got a lot of interesting things. I thank over here for giving this wonderful session, and I thank Mrs. Sudha for organizing this, coordinator Mr. Uday Kumar over here, and all the department staffs, our college management, principal, everyone who has supported us for this one day FDP. Thank you, sir. Thank you for coming over here and giving a wonderful session. Thank you, sir.
Thank you, ma'am. Thank you, Sudha. Bye.
Thank you, sir.
Thank you, sir.
Thank you.